Good afternoon, distinguished guests, ladies and gentlemen. Allow me to welcome you to our press conference. Thank you for finding time in your diaries to join us. My name's Adrian Stones. I'm one of the directors at Alaco. This means I'm dialing in from London. We are online here to talk about a report we and Omnia have jointly released today, dealing with allegations of forgery lodged against Mr Cummings in Monrovia. We have called the report "The Framework of Political Persecution, the Case of Alexander B. Cummings." You'll be able to review the document in full on our website at any point after the meeting. So here's what's going to happen over the next hour and a quarter. I will hand over shortly to Cherie Blair QC, who will speak on behalf of Omnia. Gordon Rainey will then introduce the report proper and use some slides to take you through our collective findings. Then the microphone will pass to Mr Cummings, who would like to say a few words before we open up for questions. Before I give the floor to Cherie, a few words from me on how the questions and answers segment will work. You'll need to use the Q&A function in the top bar to type in your question, so you may want to keep them brief. Please also state your affiliation. I will then put your questions to the panelists. If you want to address a question to a particular panelist, then you'll need to make that clear in your question. If you think of something afterwards, and I often do when I'm at press conferences, please feel free to be in touch with James Chiazolu, Mr Cummings' Director of Communications. So that's it in terms of preambular remarks. Mrs Blair, if I could pass the microphone to you.
Thank you, Adrian, and welcome to everyone joining us from Liberia and beyond. Several weeks ago, Alexander Cummings instructed me to form and lead a team of specialist lawyers and expert investigators to examine the allegations of forgery and criminal conspiracy that had been made against him. While it's fair to say that he was confident of the outcome, our instructions were to investigate fully and independently and to report without fear or favour. That is what we have done, and we stand behind every word in the report. We have conducted our examination of the facts and presented our conclusions dispassionately. So let's start with some context and set the scene. Alexander Cummings is the political leader of the Alternative National Congress, known as the ANC, and he will contest the 2023 presidential and general elections in Liberia as flag bearer for his party. Back in 2020, Mr Cummings played a central role in the formation of the Collaborating Political Parties, otherwise known as the CPP, a historic unification of 4 political parties opposing the current government of Liberia and the ruling CDC party. Before committing himself to public service, Mr Cummings was one of Liberia's most successful businessmen and a highly regarded international figure. Until 2016, Mr Cummings was Global Executive Vice President and Chief Administrative Officer of the Coca-Cola Company. He's the founder and chairman of Cummings Investment Holdings and the founder of the Cummings Africa Foundation, a non-profit organisation. Alexander Cummings is also a man facing allegations of forgery and dirty tricks. Together with 2 senior colleagues in the ANC, he has been accused of tampering with the agreement that constituted the CPP. That agreement is referred to as the framework document. According to the claims against him, Mr Cummings conspired to register with Liberia's National Elections Commission a version of the framework document that had not been reviewed, agreed and signed by his CPP partners. In particular, Mr Cummings allegedly doctored the registered version of the framework document by inserting an inauthentic signature page that he had effectively cut and pasted from a redundant earlier version. Strongly denied by Mr Cummings, these allegations were upheld by the CPP's own internal review and formed the basis of a misdemeanor charge being laid against him. As you may know, that criminal case is currently ongoing before the Monrovia City Court in Liberia. Remarkably, the prosecution is being led by the Solicitor General himself. However, I'm not here to make light of these allegations. Indeed, they are very serious, and if true, would strike at the heart of Liberia's democracy and Mr Cummings' personal and political integrity. But if they are not true, they raise legitimate questions as to how and why they came before the court. And on that fundamental question, our principal finding is that beyond a shadow of a doubt, the allegation that Mr Cummings and others conspired to tamper with the framework document has no legitimate foundation. Within days of launching our investigation, the weakness of the allegations against Mr Cummings became obvious. Still, in the weeks that followed, we carefully scrutinised the accusations and considered the relevant evidence, the same evidence having been available to the CPP Investigative Committee. In short, we carried out a review of the investigation and conclusions of that committee, albeit with the notable advantage of decades of experience and a specialist skill set. When scrutinised, the facts clearly contradict the allegations against Mr Cummings and show them to be false. The simple truth borne out by the evidence is that the framework document was duly reviewed, discussed, approved, endorsed and signed by the respective leaders of the parties forming the CPP. Gordon Rainey will talk you through these distinctions in more detail, but first let me invite you to keep 2 points in mind. The first is that despite all the details, individuals and parties involved, the accusations against Mr Cummings follow a classic arc. Someone has conspired to fix a process to his own advantage, but he got caught. The only problem is that for all the noise and furore in this case, there was no fixing and there was no conspiracy, at least not on the part of Alexander Cummings. Whatever the reason, be it lack of capacity, negligence, or something more malign, the CPP Investigative Committee overlooked key evidence and made obvious factual errors in reaching their conclusions. And yet, concerningly, the CPP's review and findings have been relied upon by Liberia's prosecution authority in bringing this case to court. Liberia is now confronted by an expensive courtroom spectacle, but one that people rightly think distracts from more important issues, such as how is the current government performing and who should be the next president of Liberia. Which brings me to the second point, which I will leave others to consider. What are the motivations of Mr Cummings' accusers? Why has this case been brought before the courts? And who stands to benefit from this circus? Those who care about the rule of law and the health of Liberia's democracy will recognise that the stakes are high. While our conclusions are clear and have now been published in full, the proper place for this matter to be decided is in the Liberian courts. It is not our role or our intention to second-guess that ongoing work. My sincere hope and expectation is that the Liberian judiciary will see that justice is done and bring an end to this unedifying wild goose chase. Thank you for your attention. I now hand over to Gordon to deliver a brief summary of the detail of our report.
Thank you very much, Cherie, for those compelling remarks and your introduction. Just a few quick words about who I am. My name is Gordon Rainey. I'm an associate director at Alaco, a London-based business intelligence and investigations firm. I am a trained lawyer and practiced in both New York and London before entering my current practice. I'm going to give you a little bit of background as to the chronology of events and the nature of our mandate, and then I will share my screen and go through a brief number of slides. This presentation is a short distillation of the work that we've undertaken, and I would encourage everyone to read our report in full, which, as Adrian noted, will be available shortly, if not already, on both our website and that of Omnia Strategy. So just a little bit of background to start off. At its core, as Cherie noted, the ALP's claim, which forms the overwhelming basis for the current criminal proceedings against Mr. Cummings in Monrovia, is that he and his allies secretly modified certain clauses of the framework document prior to its filing with the National Elections Commission on the 14th of July in 2020. Now, just chronologically, in September 2021, the ALP's political leader, Benoni Ure, demanded the opening of an investigation into his claims, after which the CPP formed its investigative committee. In October of 2021, that committee published its findings, stating in part that the framework document had been altered with no review or approval by any of the constituent parties. Now, that is the crux of the issue here, that there was no review or approval process. Mr. Cummings obviously maintains that these allegations have no basis in fact, and as such, has mandated ourselves and Omnia to conduct this independent and forensic investigation into the facts. Now, I just want briefly to give you a little bit of the evolution of the framework document, because in large part, the nature of this investigation has been all about version control over this document, the framework document, and the iterative negotiations through a number of drafts and among various interested parties and stakeholders. So as such, our report and this presentation, we use different terms to describe various versions of the framework document. But really, at the end of the day, it boils down to versions 1 through 4 of the same document. Now, the first version is what was used during the 19 May 2020 ceremonial Zoom signing of the document. The second version is that which was edited by the CPP's legal advisors as mandated by the various constituent parties. The third version is that which was shared to all the constituent parties by Mr. Cummings after that review. And then finally, there is the signed version filed with the National Elections Commission. Now, the first version of the framework document was concluded by the constituent parties on the 25th of April 2020. And this version, which we are calling the original FD, was then used at the Zoom ceremony on 19 May 2020, during which the constituent parties each symbolically signed a copy at their respective locations. And just to underscore the point, these signatories were in separate locations owing to COVID-19, and it was a virtual meeting and signing ceremony. After that ceremony, as many of you will know, there was quite a controversy regarding the drafting and writing of some of the clauses in the original FD. And as such, the constituent parties mandated a team of legal advisors to conduct a thorough review. Those advisors introduced a number of changes, both substantive and in format, which were crystallized into a new document, which we are calling the post-review framework document. Now, this was sent to Mr. Cummings in June of 2020. And on the 25th of June that year, Mr. Cummings created a WhatsApp chat room for the National Advisory Council of the CPP, which we are calling the NAC WhatsApp chat room. And that chat room included the political leaders and chairpersons of all the constituent parties. Mr. Cummings then shared the post-review FD, i.e. that version which contained the amendments suggested and inputted by the legal advisors. He shared that document into the chat room. We'll go into this in some more detail on the slides. Now, finally, on the 9th of July 2020, Mr. Cummings shared a new version into the NAC WhatsApp chat room. This version did not contain any substantive changes in terms of content, although its formatting was slightly different compared to the post-review FD, which was circulated by the legal advisors to Mr. Cummings and then to the various constituent parties. And finally, on the 14th of July 2020, after the signatures of the political leaders and chairpersons of the constituent parties were collected on the final framework document, the document was filed with the National Elections Commission, thereby on that day officially registering the CPP as a political entity. So that's just a little bit of background from a chronological perspective about what we were talking about here. Now, if you will bear with me one moment, I'm going to share my screen and we will walk through a brief number of slides. Now, I want to stress that this is a summary of the work we have undertaken, and I really would urge everyone to take the time to read our report, which is available on Omnia and Alaco's websites. Now, just starting off, a little bit about the process and how we went about our work. As noted by myself and Cherie, we were collectively engaged by Mr. Cummings to independently investigate these allegations of forgery and to present our findings in a report. In furtherance of that, We have analyzed the evolution of the framework document through those various drafts that I referenced a moment ago. We've scrutinized the communications by and among the constituent parties during that process of negotiating, finalizing, and ultimately filing the framework document with the NEC. We've reviewed and tested the findings of the CPP Investigative Committee as put forth in its own report. And that is critical because to go back to my earlier comment, this has largely formed the basis for the current prosecution in Monrovia. And finally, we have compared various WhatsApp chat room logs and those submitted by the prosecution in those criminal proceedings to identify and assess any discrepancies between the two. And we'll come on to that a little bit later. I think at the beginning, it's important and helpful to set out those key findings and conclusions of our report. And we will return to this slide at the end of the presentation. But just for clarity up front, I want to walk through the key findings now. And the allegation that the framework document was filed with the NEC without any proper review or approval by the constituent parties is, in our view, entirely baseless. We have found ample evidence that the constituent parties had access to, discussed, and reviewed that document, which was ultimately filed with the NEC, and that there were no objections to its contents at any time. I would underscore that it was Mr. Cummings specifically who time and time again solicited any comments and urged those to make any comments or objections in the course of that process. Now, whether deliberately or otherwise, the investigative committee failed to take into account evidence showing that its own chairman, Mr. Momo of the ALP, had participated in the review of the framework document. Now, in our view, this does raise some questions about that committee's motivations and competence. The investigative committee report is unreliable and it is flawed in its conclusions. The evidence contradicting its findings is compelling, and therefore we feel that the report cannot be deemed a safe basis for any prosecution. Despite its assurances that any omissions were inadvertent, it's difficult to attach a benign explanation to the prosecution's submission of an incomplete export of the NAC WhatsApp chat room. We will come on to that in a moment. So before we go into the key findings of our own work, I think it would be helpful for everyone on the call for us to outline specifically what the critical allegations of the ALP were and those upon which the CPP Investigative Committee based its finding. Now, findings regarding the introduction of changes and a lack of review process, which really is at the heart of the matter. Now, the investigative committee stated that the content and the structural differences, were introduced between the original framework document and that version of the document, which was filed with the National Elections Commission. The report also stated that there are differences in the formatting, but not the content, between the post-review framework document and the final framework document. Now, this is critical. The committee report stated that, quote, there is no documentation proving that the constituent parties reviewed and ratified the post-review framework document, i.e. that which was the result of the legal advisor's review and amendments, ahead of filing that document with the National Elections Commission. Now, we take this to mean that it is the investigative committee's position that there was no such review at all. Now, also, there were findings in the committee report with respect to the attachment of a signature sheet. Now, first, the committee report maintained that the post-review framework document had been approved, that once the post-review framework document had been approved, that 5 copies should have been printed, signed by all parties, and notarized. The committee claimed that this procedure was not followed. It also alleged that instead the signature sheet of one of the copies of the original framework document, and that is in reference to the version that was in the possession of the various constituent parties at the 19 May 2020 Zoom ceremony, was extracted and then somewhat surreptitiously attached to the framework document, which ultimately was filed on the 14th of July with the NEC. Now, those are the investigative committee's report, which I would encourage those of you who haven't already you should read that in full, but those, insofar as our work is concerned, those really are the key findings. So now I think it would be helpful if we go through the facts as we have uncovered them. Now, turning to the Investigative Committee report's discussion of the review process. Now, you'll recall that they had said that there were content differences between the original framework document and the later versions. That is not in dispute, and moreover, it is natural and it is the logical consequence of the review of various legal advisors and their suggested amendments. So we see nothing untoward about that. That there are formatting changes between the original framework document and later versions of the document is frankly inconsequential from the point of view of an integrity of the process. These are not substantive changes, and they have no effect on the operation or meaning of the provisions of the framework document. Now, critically, the real key point is whether the changes in content made by the CPP's legal advisors, as were set out in the post-review framework document, were approved by the constituent parties prior to the filing with the NEC. And the Investigative Committee maintains that they were not. And our review has demonstrated that this is patently incorrect. By claiming that there was no such review, it seems clear to us that the committee has ignored a host of pertinent communications. For example, upon sharing the post-review framework document into the chat room on the 25th of June, 2020, Mr. Cummings set out a specific time frame for next steps, which included 3 days to review and provide feedback on that post-review framework document. And he noted that these were, quote, the dates we discussed and agreed at Tuesday's meeting. 2 days later, on the 27th of June, Mr. Momo of the ALP and Senator Abraham Darius Dillon of the LP, they acknowledged receipt of the document and the feedback deadlines via messages, which they separately sent into the NAC WhatsApp chat room. 2 days later, on the 29th of June, Mr. Momo informed the chat room that the ALP was, quote, working hard on the resolution to endorse the framework document. And finally, on the 30th of June, Mr. Cummings reminded everyone in the chat room of the need to stick to deadlines and offered to discuss any proposed changes to the post-review FD during a Zoom meeting scheduled for the 1st of July. Now, we won't spend too much time on these next two slides, but I think it is helpful to show visually to everyone on the call the actual logs and the communications out of this chat room. And we have highlighted some of the more pertinent ones, which reflect some of the quotes and communications I have just mentioned. Now, furthermore, by claiming that there was no review of the framework document, the Investigative Committee seems also to have ignored that on the 1st of July 2020, during a Zoom meeting on the 1st of July, the leadership of the constituent parties gathered to provide updates on the approval process. During that meeting, Mr. Momo confirmed that the ALP saw, quote, nothing major with the legal advisor's edits to the framework document. Now, we have provided a recording via a YouTube link to this meeting, and it is contained in our report, which, as I said, is available in full. And just for those who are particularly anxious to see that recording, the link is available in footnote 16 on page 22 of our report. On the 7th of July 2020, Mr. Momo asked the chat room whether the national chairperson should be signing the framework document, which received a reply the same day from Mr. Cummings informing him that the signatures were required. Mr. Momo and Mr. Ure signed the resolution endorsing the framework document before a notary public on the 7th of July 2020. And that date is very important because at that time, the post-review framework document, which included all the substantive changes from the original FD, had been in circulation for some time and subject to discussions between the constituent parties. And I might add, subject to repeated requests by Mr. Cummings to receive any comments that various parties may have to that document. Now, by claiming that there was no review of the framework document, the CPP committee, investigative committee, also ignored that Mr. Cummings sent a message at 2:04 on the 7th of July 2020 into the chat room, informing the parties of the final steps of the framework document approval process, including the need to submit party resolutions. On the 9th, 2 days later, on the 9th of July, Mr. Cummings shared with the chat room the final FD and informed everyone in that chat room that for the information and record of its members, he had just shared the final copy of the CPP framework document. And in a message on that same day, later that same day, Mr. Momo of the ALP acknowledged receipt of the final framework document, saying thanks and raising no issues with its content. So I think you're starting to see quite a thorough and comprehensive evidence trail of the documents, the various drafts of the documents being shared with all parties and giving them ample oxygen and opportunity to air any concerns that they may have. Again, we're not going to focus too heavily on these slides, but these reflect the actual chat logs, which evidence some of the communications that I have just gone through. And I would perhaps point you to the final highlighted one, which is Mr. Momo acknowledging receipt of the final copy with the word thanks. Now, this is a fairly critical aspect of the tale, and that is the signature page allegations. As I mentioned earlier, as did Mrs. Blair, the committee found that the signature sheet in the framework document filed with the NEC was extracted from a copy of the original framework document. Now, we believe that this is critically undermined by two very basic facts. First of all, there was no single signature sheet that emanated from that 19 May 2020 signing, which would have borne all the required signatures of the political leaders and chairpersons of the constituent parties. And just to state the obvious, that is because of the nature of that meeting. Each of the signatories was in different locations. And as far as we have seen, there was certainly no collection and collation of everyone's respective signatures, and certainly not on one signature sheet. And this is very important, and I would urge everyone to listen very closely. The signature sheet itself in the original framework document, and that in the framework document which was filed with the National Elections Commission, containing all the signatures of the political leaders and chairpersons, they are substantially different in structure and in signature order. And this is apparent to any viewer who would compare the two pages side by side, which we will do now. Now, if everyone would take a look, on the left side of your slide is the signature page which accompanied the original framework document that was in circulation at the time of the 19 May Zoom ceremony. And on the right side is that signature page which is included in the final and filed version of the framework document with the National Elections Commission. And as you'll see, these are two very different pieces of paper. On the left, the original signature sheet, all of the signatories are listed in one single column, top to bottom. On the right, it is two columns. Furthermore, the order of the signature is different. So I think everyone on the call would be inclined to agree that the proposition that the left-hand signature sheet was surreptitiously extracted from an earlier framework document and slipped into that which was filed with the National Elections Commission is just simply not possible. They are two different pieces of paper, and it just does not make sense on a very fundamental level. Now, we have focused primarily, and our mandate was to focus primarily on examining the actual documents, understanding the changes and when they were made, and ensuring that there was an appropriate and comprehensive review and approval process. And we've covered that to some degree here in this presentation, and we do so exhaustively in our report. But I think at the end, and we're coming to the close of our presentation here, I think it merits a little bit of time to discuss the omissions that were found in the prosecution's WhatsApp submissions. And I don't think that this issue is new to anyone who is listening. For those who maybe aren't aware, The prosecution submitted what it claimed to be full chat room logs out of that NAC WhatsApp chat room, and subsequently it was conceded that there were omissions in them. And I think it's just for the sake of completeness worth going through those briefly. Now, during the criminal proceedings against Mr. Cummings, the prosecution, which was led by Solicitor General Serenius Cephas, submitted a number of exhibits into evidence based on WhatsApp correspondence between the various constituent parties. Specifically, Exhibit P6 was submitted into evidence by the prosecution and was presented by the prosecution as an exported copy of the correspondence in the NAC WhatsApp chat room, covering a lengthy period of 22 June 2020 to 2 December 2021. We have reviewed and analyzed that submission, and we have compared its contents to a fully authenticated export of the same chat room, which we extracted forensically from Mr. Cummings's cell phone. Now, that analysis of these two exports, i.e. that provided by the prosecution in its court submissions, and the full copy which we have reviewed, reveal a number of significant discrepancies, and I don't think this is news to anyone. This has been in the press, but namely, a number of crucial messages which were sent into the NAC WhatsApp chat room are missing from the prosecution's submission. Now, first of all, in that submission, the prosecution's purported export of the chat room, it does not contain any messages that have attached files, which frankly, considering that we are talking about whether or not various documents and versions of those documents were put in front of all interested parties and giving them an ample opportunity to review, the fact that those attached documents are missing from the prosecution's submission is quite alarming. And it bears no reference to inform the court that the messages are missing. And among others, just to walk through quickly, these are a few that were missing from the state's submission. A message sent on 25th June, which we referenced earlier, in which Mr. Cummings shared the post-review framework document with the chat room. A message on 9 July, in which he shared the final framework document. And furthermore, in the Exhibit P6 of the prosecution, there were many messages sent into the chat room between 2 July and 19 July, which are missing. There is no reference in the exhibit alerting the court that these messages are absent. And this is especially significant, we feel, because there are several messages missing, including but not limited to a message sent on the 7th of July by Mr. Cummings informing the parties that the final steps of the approval process, a message sent on 9 July by which Mr. Cummings shared the final framework document with the group, a message sent on 9 July by Mr. Momo in which he acknowledged the final framework document, saying thanks. All of those we discussed earlier in the presentation, but I think it is important to note that all of these, which incidentally or not all happen to be quite favorable to Mr. Cummings, were not in the original state submission. As we know, we're not going to go into this in great detail, but we know that subsequent to that submission, the state amended its submission and conceded that there were missing pages and that this was a benign and innocuous mistake with no malign intent on the part of the state. Well, we would only note that their explanation that it was an inadvertent omission of certain pages of its copy of the logs is slightly curious, because as this slide suggests, the point at which the state submissions begin and its omissions begin actually fall in the middle of a particular page. So it seems to stretch belief that, or feasibility, frankly, that their error was simply down to missing pages. We are almost finished here. I just want to restate at the end of this, and again, this has been a very brief overview. Please do read our report in full. But to restate those findings and conclusions that I went through at the beginning, after an exhaustive review of all the evidence, we believe that the allegation that the framework document filed with the NEC had no proper review or approval process, as stated by the investigative committee report, is entirely baseless. We have found ample evidence that all constituent parties had access to, discussed, and reviewed the document, and that was filed with the NEC, and that no objections to its contents were raised at any time, despite multiple efforts by Mr. Cummings to elicit from any parties any concerns or comments or requested amendments. Now, whether deliberately or otherwise, the CPP Investigative Committee failed to take into account evidence showing that its own chairman, Mr. Momo of the ALP, participated in that review of the framework document, which in our view raises some serious questions about the committee's motivations and competence. The committee report is unreliable and flawed in its conclusions, and the evidence contradicting its findings is compelling. As such, we feel that the report cannot and should not be deemed a safe basis for prosecution. And finally, as we were just talking about, despite its assurances that any omissions were inadvertent, it seems difficult, in our view, to attach a benign explanation to the prosecution's submission of an incomplete export of the NAC WhatsApp chat room in those proceedings against Mr. Cummings. That is the end of, again, I hope we didn't go too far over, but that is the end of our summary of the findings. And again, it is a précis and a distillation of our broader report, which I would advise everyone please to review when you have the time. It is not too onerously long.
Gordon, we're going to open the floor to Mr. Cummings now. And Alexander, you are now live.
Thank you. Thank you, Adrian. Let me first of all thank Mrs. Blair and Mr. Rainey for the very detailed and comprehensive investigative report. Let me also state emphatically that these allegations against me, as proven by this report, is baseless and is politically motivated. After almost 40 years of working in business internationally and in Liberia, working philanthropically, and now in politics, my integrity and my character are two things I hold dear, and have been deeply, deeply offended by these baseless allegations by Mr. Ure and the ALP in connivance with the Unity Party and the Liberian government against me. It's unfortunate that our democracy is being put at risk. It is unfortunate that President Weah, the Minister of Justice, and his Solicitor General are weaponizing the judicial system in Liberia to prosecute their political opponent. But I'm very pleased and happy that independently, Mrs. Blair and Mr. Rainey and their teams have reviewed the facts, have reviewed all the documents, all the evidence, and have concluded that the allegations are baseless. So thanks again, and we look forward to taking questions from the press.
Thanks, Mr. Cummings. Let me say a couple of things before I get deeply into the questions. We said at the start, if you want to ask them, you need to put your name and affiliation alongside. So I've got a couple of really fruity, good questions from someone who at the moment wishes to remain anonymous. So if you want those questions dropped into the mix, I'm going to need a name. So back to you. Everyone else who's on the call, please do formulate questions as we go. The first one I'm going to address to Mr. Cummings, if I may, and this is from a gentleman from Africa Briefing magazine by the name of Desmond Davis. Desmond, thank you for this. Alexander, the question is, how will Liberians view your decision to turn to an external law organization to undertake a review on your behalf? Is the system in Liberia, the legal system in Liberia, so compromised that you felt it was necessary to do this?
Actually, Desmond, I think Liberians and the judicial system understand why we needed to do this. The fact that the prosecutor deliberately, although they claim it was inadvertent and a human error, kept evidence away from us during the discovery process was one reason why we felt we needed to go outside. Remember, this is the Solicitor General of the Republic of Liberia and his team who claim that this was human error inadvertent. Secondly, the Minister of Justice and the same Solicitor General who were prosecuting this case have had a public feud about the evidence. The Solicitor General claims publicly that he quashed the allegations because it was baseless, but the Minister of Justice reinstated it. The Minister of Justice claimed it was incorrect, and 4 months into the trial, the Minister of Justice is asking for evidence, which apparently still has not been produced. All of these factors required that to protect our integrity, our character, we needed to go outside and get credible, independent individuals who have done this work in other parts of the world to come and look at the evidence and opine so that the facts can truly, in this case, prevail.
Thank you, Mr. Cummings. I have one for Desmond. Also has put a question to Cherie that I would I'll just paraphrase slightly, if I may. Cherie, as we got into this and understood that this was the basis of a case before the Liberian judicial system, any sense that this should never have been taken to court? This is for Cherie, to the extent that we can comment on this.
First of all, let me make it quite clear, we are not reviewing the process that's going on in the court at the moment. What we have looked at is the report, the investigative report of the committee, and of course the decision of the prosecution to, acting on that report, bring a trial before the courts. And in relation to that, I think we can categorically say that the investigating committee report does not provide a proper basis for any prosecution, and secondly, that the prosecution itself, not only in taking it forward on the basis of that flawed report, but also in the actions that it has taken since, in apparently losing documents, is not behaving in a way, the high standards that one would expect of any competent prosecution authority. The courts, of course, are seized at this at the moment, and I'm sure that they will reach the proper conclusions.
Cherie, thank you. Let me put a question myself, Mr. Cummings. On the basis of the report which we've now published and which will be looked at by journalists in and outside the country, should this trial continue at all?
Well, Adrian, the trial should not have been brought in the first place. Whether it continues or not is up to the judge and or to the government. It is within their authority to end this case. And I'm hopeful that these facts, as outlined by Gordon and Mrs. Blair, will lead to the correct conclusion, and that this trial, which should not have even been brought in the first place, will hopefully be quickly dismissed.
Very good. Cherie, I've got another question. Do you, can I hear the same question from you, Cherie? Do you think this should continue, or is that up to the Liberian judicial process?
Well, I would reiterate what Mr. Cummings has said, that there are two ways in which this case could come to an end. One is by the prosecution recognising that because of the flaws that we have pointed out, that there isn't a case to answer, and therefore properly they can withdraw the case. And the second one, which is in the hands of the defence lawyers and the judge, is that the judge can take a decision at the appropriate time that there is no case to answer and end the case if invited to do so by the defence.
Cherie, thank you. I'm just going to issue what is effectively a last call for questions. If you've got any, get typing now. I have another one for Mr. Cummings, and this is again from Desmond Davis. So thank you again, Desmond. What does it say about the democratic opposition process in Liberia if a coalition could implode so spectacularly amidst claims and counterclaims of impropriety within the opposition group?
Unfortunately, what has happened to the opposition in Liberia has been disappointing. But I will point out and want to reassure Liberians that there are others in opposition who want to do the right things for Liberians, who want to offer Liberians an alternative to the failed presidency of President Weah. And so although the original members of the CPP have now fractured, the Labour Party and the ANC are still in the CPP, and we reach out to other political parties and actors to join the CPP. I remind Liberians that the CPP is an idea, and the idea is to restore good governance to Liberia, is to restore economic vitality and growth to Liberia. And that idea has not died as a result of the departure of the ALP and the UP. That idea is alive and well, and together with other Liberian political parties and institutions, we will reorganize the CPP and provide a real alternative to ensure we make President Weah a one-term president.
Mr. Cummings, I think that's probably a right point to draw this to a close. One small admin point from earlier on: if there were any bits of Cherie's remarks that you couldn't hear, then if you get in touch with us, we will release a transcript of those remarks to you for the record. So it remains for me to thank Mr. Cummings for coming on, Cherie for the opening remarks, and Gordon for doing the heavy lifting on what was in the report. As I said at the start, if you have any questions, you think, darn, I should have asked that question and now it's finished, you know how to get that question to us. Meanwhile, the reports are fully available, so take a look. And on that note, I wish all of you a very good afternoon. And thank you.
Good afternoon.
Good afternoon. Thank you.